Hello students, here is Ashu Gupta, Assistant Professor. Again welcomes you all on the behalf of the Interest Law College. In today's lecture number 4, we are going to discuss about the sources of international law. So now let's open the box and start the slide. Today we will discuss on the sources of international law. So let's start and see how the slides going on. Now you may see the sources of international law. These are the primary and secondary sources which are already discussed in the previous lectures also. Now here we will discuss it in details. So let's start from the international custom as one of the most important source of international law. And the sources of international law are those actual materials from which an international lawyer determines the rule applicable to a given situation. Article 38 of the Statute of International Court of Justice, which is already discussed in the previous lectures, enlists such material sources of international law. And there are all kinds of sources in this statute, including primary and secondary. Part 2 of Article 38 of the Statute enlists secondary source of international law. You know very well about the that things which is already discussed in the previous lectures with you. Now you can see that here two tables which provides you primary sources and the secondary sources. If you see that in the primary sources there is a four parts of things. The first one is international custom, the second one is international convention or treaties, the third one is general principle of laws, and the fourth one is judicial decisions and teachings. And if we will discuss about the secondary sources, and there is some writers says that that is a secondary sources, and some says that it is a part of the primary sources also, because the origin of the both of the sources is governed by the Article 38 of the ICJ. So secondary sources is that writings of legal scholars and ex equo ad bono, that means equity. We are firstly discuss about the first important source of international law, that is international customs. And in this lecture we will discuss about the international customs in details, which is an important question according to your exam papers. So see that what is the international customs and the essentials of international custom. Basically we already know about the custom, what is custom or usages, which is a very long pattern in the practical aspects. So there is a definition of custom. Custom basically is the original and oldest source of international law also, as it is already the source of law, source of all laws basically. And at a time it was the most important amongst the sources, and that's why it is most important part of the custom. And a custom is the foundation stone of the modern international law, because it was so large part contained in the name of the customary rules at the point of the international law, which differs between the nation to nation, which governs with the nations nation to nation. And international custom basically may mean a kind of qualified practice distinguished from others. Already say that by the existence of a corresponding legal obligation to act according to this practice. They evolve through the practices of and uses of nations. That's why that is most important to know about the customs and what is the definition of customs. And they are not the creature of the sovereign or a state. That is basically the common acceptance of the public, of the society. And in order to establish the existence of an international custom, primarily three essential elements are required to be present, which are duration, continuity, and generality. We will discuss in the next slide. Let's move on the next slide. Here we can see that the essentials of the international custom. A usage may become custom. We already know that even in a short time, all depends on the circumstances of the case and the nature of the rule involved. Practices relating to continental shelf and rules relating to airspace have become custom in a short time. And there is a essentials of the international custom. The first one is duration. When a particular usage is practiced by the state for a long duration, for a long time, it has a tendency to become custom. Uh, how much time usages take to transform into custom is no question. There is a no question that how much time a usage is uses by the public, and there is no data maintained by anyone. That is a immemorial time, which is very essentials to create a customary law. That's why that is the most important essentials of the international custom. And Lord Stovall also says that the period of 100 years which has since elapsed is simply sufficient to have enabled what originally may have vested in the custom or committee. That's why sometimes some writer says that 100 साल पुराना होगा, 200 साल पुराना होगा, 500 साल पुराना होगा. It may be a long term, immemorial time पर depend करता है. तो that is a long duration process. It is an essential part of the international customs. Let's move on the next slide. The second part of the essential features of international custom is uniformity or consistency. Consistency means a thing which is very consistent between the society and adopted by the common person as a will. That's why it is a uniform or consistent. An international must uniform and are consistent. When a thing is consistent or uniform, that may be adopted as a custom. So that's why that is the second important essential part of the international customs, wherein a practice is required to be followed consistently by the states. And in other words, if you can say that there is a vast definition given in the case of lotus, that is a very important case in the international law. We will discuss it later on. The practice should be constant and uniform. PCIA already says that for the uniformity or the consistency of anything, that should be constant and uniform. So let's move on the next slide. The last one is the generality, which is very important part of that international customs. It is essential that a usage should be practiced by most of the states in order to transform into a custom, although it implies that there is no rule which prescribes that the consent of all stated is a necessary condition to the formation of a customary rule. So that's why generality is a very important part to become a custom, to become anything into a custom. And according to the West Rand Central Gold Mining Company Limited, VR, and the fisheries jurisdiction case, that is the most important case of international law. There is two cases, West Rand case and fisheries jurisdiction case. It was held that it must be proved by satisfactory evidence that alleged that it can hardly be supposed that any civilized state would repudiate it. And in the fisheries jurisdiction case, the court also says that the expression generally accepted, which is already discussed by me, which may mean that a general customary rules is required to be accepted generally by the state. It allows that if a usage is practiced only by a limited number of states, it will not transform into a custom. So that's why you can see that there is a three essential parts of the international custom. One of the basically duration. The second one is constantly governed by the society, and the third one is generality. Hope you will enjoy the session and successfully enumerated it into your study and be benefited from this presentation. Thank you. We will meet soon again with a new session and the second part of the primary sources. Thank you very much.